Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about something called civil forfeiture. Civil forfeiture is a process whereby law enforcement officers can take assets away from people when they believe that those assets may have been involved in illegal activity. Civil forfeiture allows provincial governments in Canada to seize property, but not just from criminals. They can also seize it from people who have never been charged or even suspected of a crime. All the government has to do is show that the property was used by someone, anyone, as an instrument of crime or that it was proceeds of crime, and they can take that property away from its owner with no compensation. Many advocates believe that these laws are unfair, and it's especially troubling that the assets seized under the legislation are often sold and the money used to fund the very police forces who are doing the seizing. The charity that I work for, the Canadian Constitution Foundation, has been involved in challenges to civil forfeiture laws in Canada, including a new case that's being heard in May. Today, to talk about that case and the issue of civil forfeiture, are three legal experts. Executive Director of the Canadian Constitution Foundation, Joanna Barron, Ontario lawyer Jessica Karijan, and Jessica Maganet from the British Columbia Civil Liberties Association. Thank you all so much for joining me today. Now, Ms. Karijan, I'd like to start with you. Can you explain exactly what civil forfeiture is and why it is that the police can seize assets from people who haven't been charged or even suspected of a crime?
Sure, Christine, and thanks for having me. At a high level, civil forfeiture is when the government seizes property under suspicion of its involvement in illegal activity. The stated purpose of these laws is to A, compensate victims of crime, and B, prevent those who engage in unlawful activities from keeping the property that was acquired as a result of those unlawful activities. In short, the reason why police can seize assets from people who've not even been charged with crime is because the laws specifically allow them to do that. For example, in Ontario, we have the Civil Remedies Act, and it contains a section that is called proof of offenses. Ironically, the section under the act says that an offense may be found to have been committed even if a person has not been charged with the offense.
I mean, that seems pretty wild to me, that people can take your property if you haven't done anything wrong. Ms. Barron, what are some of your organization's concerns about civil forfeiture?
Well, just broadly, it allows the state to seize property that could belong to an innocent party before any wrongdoing is proven, or even in some cases, in a case that we were involved in that I'm sure we'll talk about, alleged. And there's a total lack of transparency. There is just basically a cash grab maneuver by the government that is totally disconnected in practice from its sensible purposes of deterring crime and compensating victims.
So, Ms. Maganet, I know the BC CLA has done a lot of work on civil forfeiture. Can you explain some of the issues that your organization has with these types of laws?
Certainly, and we have many issues, but I'll focus on three. First of all, civil forfeiture laws allow and even require judges to order forfeiture in cases where it would be disproportionate to the unlawful activity that is alleged to have occurred. Second of all, there are
And
massive access
can
to
I just stop
justice.
you for a second? By proportionality, you mean taking valuable assets when the crime alleged is pretty small. Is that what you mean?
Absolutely. Yes, so it could allow the state to seize something that is incredibly valuable for an unlawful activity that may not be very serious. It doesn't need to be a criminal offense. It could be a victimless unlawful activity. Second of all, there are serious access to justice concerns with the civil forfeiture regime. I know, at least in British Columbia, almost all cases settle or are not disputed because it's expensive to litigate them. And it's really challenging to litigate them. Legal aid isn't available for civil forfeiture cases. Assets secured by a preservation order during the legal proceedings can't be used for legal expenses in British Columbia. And often the cost of the value of the assets seized just simply doesn't justify the cost of hiring a lawyer. A third concern I'd like to flag is, at least in BC, the Civil Forfeiture Office operates under a self-funding model, which means that the incentives of the office can be distorted towards trying to focus on filling its pockets, meeting its budget targets, and away from what it really should be doing, which is focusing on deterring organized crime.
Welcome back to Canadian Justice, where we're talking about civil forfeiture, which is when the police can seize assets that they suspect are related to a crime. Now, Ms. Karijan, you're working with our organization, my and Joanna's organization, the Canadian Constitution Foundation, on a case about civil forfeiture that's going to the courts in May. Can you explain what that case involves?
Sure, Christine. I'm really excited about this case. It's called Norwood Estate, and it involves assets, including a family home, that were seized by the government as part of a drug trafficking prosecution, where the accused later died before his criminal charges. In other words, he had not been found criminally guilty before his death. The government had commenced legal proceedings for the forfeiture of the family home, but they didn't proceed. And a determination as to whether the home was the proceeds of crime was never concluded. Despite this, what we have in this court, or this case rather, is that the court relied on a single provision of Ontario's Civil Remedies Act to approve a forced settlement between the deceased estate and his mother, who alleges to have a claim to the home. In my view, the error the court made in this case was putting the cart before the horse. The government began disposing of assets before there was even a determination made with respect to whether those assets were the proceeds of crime.
So this case certainly seems unusual. There's a dispute between two of the parties, the estate, I guess perhaps the widow, and the mother, and they're in a dispute about who owns the house, and the government does an end run around that dispute and just awards it to the mother. What could be some of the consequences if the law on civil forfeiture in Ontario is interpreted this way to allow the government to do things like this?
Well, you make a really good point, Christine, in my view, that this case sets a dangerous precedent and it could have a negative impact on individual property rights. For example, a good example, and the example raised by Canadian Constitution Foundation in its press release this week, was to imagine if you're in a dispute with a friend about the ownership of a car. Your friend, or you lend that friend, the deadbeat friend, your car, or your friend rather lends your car to their deadbeat brother who uses the car for illegal activities, for example, a drug deal. If the police seize that car before it can be determined that it's the proceeds of crime, and then imagine that the Attorney General then awards your car to your friend, surely that's not how this law was intended to be used. And it's not aligned with the intended purpose of how the legislation is intended to work, which is why the Canadian Constitution Foundation decided to intervene in this case.
Yeah, that's a great point. Ms. Barron, maybe you could elaborate on why CCF cares about this issue and why they decided to get involved in this particular case.
Yeah, I think basically Ms. Karijan really summed it up, but it's basically that when we look at the law, the Ontario Civil Remedies Act, it's supposed to preserve assets until there's a determination about whether they actually are proceeds of crime. And here you have the Crown, the Attorney General, making a deal with a third party who's not even party to the prosecution or the legislation, so that the assets may be completely depleted before we have a court determination as to whether they are at all the proceeds of crime. So it's just it's an end run, again, around the legislation. It greatly undermines the rule of law, and it really undermines property rights. We have a lot of talk in Ontario right now about the property market. What if the government could assign your property after your death to a third party with no basis in law? It's just arbitrary and it can't stand.
I think one of the issues is that in Canada, unlike in the United States, we don't have entrenched property rights in our Constitution. Ms. Maganette, can you talk about that a little bit, about the role of property in the Charter, in our Constitution, and your perspective on that?
Certainly. So the Canadian Charter of Rights and Freedoms does not protect a right to property, which could make it challenging to challenge civil forfeiture legislation on a charter basis. But that doesn't mean that civil forfeitures don't raise constitutional issues. And you see this particularly in cases that involve information sharing between the police and the Civil Forfeiture Office, and a blurring of the line between what's supposed to be a civil proceeding and a criminal proceeding. In fact, recently in a 2019 decision in BC, a trial judge commented that a situation that occurs here where RCMP officers will work very closely with the Civil Forfeiture Office and even share office space raises constitutional concerns.
I'm really fascinated in this criminal civil debate about where the law fits. We're going to get back into that conversation after these commercial messages. Welcome back to Canadian Justice, where we're talking about civil forfeiture. Now, Ms. Barron, this new case that we just spoke about in the last segment isn't CCF's first case about civil forfeiture. Your organization, my organization as well, is also involved in another significant case in Ontario related to the seizure of a rental property. Can you tell me about that case?
Yeah, so it's quite a shocking case. It involved a husband and wife who owned several rental properties in the Orillia, Ontario area. They rented them out at under market rates as rooming houses to low income tenants. They actually had a history of doing work to alleviate poverty, rather. And it was alleged that some of the tenants were selling drugs, whether in or around the properties. It was never clear. And the Ontario government actually seized these rental properties without proving the allegation of the tenants who were selling drugs, on the assumption that some of the rent monies had been paid for with the proceeds of crime.
And there
from
was
selling
no allegation in that case that the actual landlords here were involved in any criminal activity.
No, absolutely not. There was no suggestion of that. In fact, it was acknowledged that they maintained the property, preserved it well. It fell into disrepair while it was seized by the government. They brought a motion to seize it permanently. And after 6 years of litigation and negotiation with the Ontario government, the Canadian Constitution finally enjoyed seeing the Ontario government drop its attempt in 2018. So this is after 6 years to seize the property and actually return the cash from the sale of the properties to this couple.
I mean, what's so compelling to me about that case is this family was providing a home for low income people, and they were punished by the government by having that property seized, devalued, and then sold for a fraction of what its value should have been. You know, the seizure of a home is particularly egregious. Ms. Maganette, can you tell me about what types of property you commonly see getting seized under the Act, at least in British Columbia?
Certainly. So we commonly see cash being seized and vehicles, but there are a lot of other strange things that are seized. According to 2018 article by CBC, some of the items seized that year included a Wayne Gretzky rookie card, jewelry. The state tried to seize a violin, a kayak, a coloring book. And what I think this shows is that our law has moved so far past its original purpose of targeting organized crime and taking the profit out of crime, and has really gone into bizarre territory.
I mean, my understanding is British Columbia has a registry where you can see that type of thing. Is that correct? They actually publish information in British Columbia about what the government has seized.
I have seen lists of what's seized through access to information requests, but I'm not sure if it's available to the public.
I mean, certainly, it just is a transparency issue. We should know what the police are taking, what the value of those items are. I think it certainly would be a valuable reform. Ms. Karijan, I want to turn to you. One of the concerns that I see with civil forfeiture is proportionality, which Ms. Maganette mentioned at the beginning. Relatively minor offenses, it can result in the loss of valuable property. In the case of Norwood, it was actually the family home, although I understand that the charges were serious in that case. Another concern is that if the property isn't Yeah, valuable. It may not even be worth the legal costs of fighting back to get your property returned. Can you comment on that problem?
Sure, Christine. I think that's a legitimate sort of concern for exactly the reasons that you've spotted. Persons who have had their property seized by the state on the mere suspicion that they have had some involvement in crime or maybe the proceeds of crime may decide that getting back their property is more trouble than it's worth, or they may lack the monetary resources or legal wherewithal in time to navigate complex laws. This is problematic because revenues generated through successful forfeiture proceedings are, in fact, returned to provincial governments and their law enforcement agencies, coupled with the reality that many people won't even be able to recover their property or bother. Government authorities may, in fact, be emboldened to seek forfeiture over even more property without regard to the original objectives of deterring crime and compensating victims. In my view, the result is that civil forfeitures would be then being used not for their intended purpose and would be, in fact, being used for the purpose of raising funds for local governments and authorities.
I'm really interested in the issue of compensating victims. When we come back from this break, we're going to talk about that issue. Welcome back to Canadian Justice. I'm Christine Van Gyn, and we're talking about civil forfeiture. Now, Ms. Maganette, one of the stated goals of civil forfeiture is to compensate victims. We see a lot of this money actually going to police forces. How easy is it for victims actually to access the money under this regime that's supposed to be used to compensate them?
You raise a really great point. We know in BC that most of the money is not going back to victims. In fact, less than 2% of the money that's been seized since our Civil Forfeiture Act came into force has gone to victims. In order for a victim to access the money, they must have suffered a financial loss as a direct result of the unlawful activity that resulted in the forfeiture. And then they need to apply to the Civil Forfeiture Office, and there are a few other conditions they need to meet. But of course, civil forfeitures often take place with respect to unlawful activities that don't have a clear victim. So, I mean, in BC, we've even seen civil forfeiture used in the context of natural resource law offenses. So you could see how the state could be amassing a lot of money that does not have an eligible victim to claim it.
I mean, yeah, it doesn't seem to make a whole lot of sense that there are these victimless crimes where you have valuable assets being taken by the government. Now, Ms. Barron, you have at CCF written a report that suggests a few changes to improve civil forfeiture law. Can you outline what some of those suggestions for improvements to the law are?
Absolutely. So first, there needs to be full financial accountability. All of these offices should provide an annual report detailing what they raised and what they paid out. Basic principle. Second, it should only be available after the property owner has been found guilty of a provincial offense. Finally, the burden of proof should be on the state that they can claim the goods, not on the person whose property has been seized. Right now, there are hearings where these property owners can be cross-examined, which can turn into a total fishing expedition. And then finally, there should be a focus on the objectives of the legislation, namely compensating victims and deferring crime.
Deterring crime, yeah. Ms. Maganette, what are your views on some of the ways that these laws could be improved?
There's a lot of room for improvement. The first change that I will speak to is the need for data collection on who's being targeted by civil forfeiture laws. There is tons of research in the States about how racialized and poor communities are disproportionately targeted by these laws and disproportionately impacted by them. And we simply don't collect this data in Canada, but we know that racialized and poor communities are over-policed and underprotected, and we suspect that the same is true with respect to civil forfeiture laws. Second of all, the BCCLA wants to see administrative forfeiture abolished, which is a process that allows property to be forfeited to the state with little to no judicial oversight. It's an even faster version and more dangerous version of normal civil forfeiture. And finally, Oh, sorry,
So,
go
no,
ahead.
go ahead. Sorry, continue your thought.
The last point I would raise is that civil forfeiture laws need to give judges adequate discretion to ensure that the forfeiture is proportionate, is fair based on the type of unlawful activity that occurred.
And, I certainly think that entrenching property rights in our Constitution would not hurt. I think it could help with this issue tremendously. Ms. Maganette, Ms. Karijan, Ms. Barron, thank you so much for joining me today. I think that we have all learned a lot from this conversation about an area of law that is not talked about a whole lot. So thank you so much for your time and your advocacy. We've heard today about some of the problems with civil forfeiture laws across Canada, how these laws can unjustly deprive innocent people of their property, and that the cost of fighting forfeiture often means people can't afford to get their property back. We've also heard about a disturbing case in Ontario where the government awarded property to a third party. Essentially, it's inserting itself into acting as judge and jury in a legal dispute over the property's ownership. We've also heard about how the money recovered from civil forfeiture is supposed to help the victims of crime, but in fact does more to fund police operations. Does civil forfeiture law in Canada need reform? Do victims of crime need these laws? Or does it result in the victimization of innocent people by the government? You be the judge. I'm Christine Van Gyn, and remember, a freer Canada starts with you.